Imagine you're relaxing at home when suddenly police start pounding on your front door, demanding they come inside, all in the name of a welfare check. Before you can even respond, they kick down your door and detain you. Why? All because a neighbor made a baseless claim and cops used a legal loophole to justify invading your home. This isn't a rare case, and it happens much more than you think. But if it actually happens to you, do you know your rights? I'm Jeff Hampton, former prosecutor, now the people's lawyer, and I've seen cops over the years use a lot of creative ways to justify getting into your house, all in the name of making sure that you're okay. In today's video, I'm breaking down the true story of when cops take it too far and what you can specifically do to protect yourself if cops try these tricks against you. Stick around, because what actually happened to these officers in this particular case will shock you. Let's start by looking at this footage where protesters in a neighborhood upset a woman who was trying to get some sleep. She became so frustrated, she came outside, and when a 17-year-old kid got up in her face, she got very frustrated, spit in his face, and as you know it, cops were called.
They did the spitting on the kid's face.
Surveillance video takes us to the home of Stephanie Rapkin on June 7th, 2020.
What's going on?
336, 1023.
Is that him over there?
Witness and we have on video.
Okay.
She came out, she was trying to engage, she pushed him.
Officers respond to an assault complaint from a small group of protesters gathered outside.
You people are so incredibly stupid, it isn't funny.
You spit on a 17-year-old kid.
This man tells officers Rapkin came out of her home and shoved him. She then went inside her home and locked the door.
What happens if she doesn't come out?
We're working on that.
Now, I have no idea if these witness statements were true or not, or if it actually went down like this. But what we do know is police officers gathering information from these witnesses that were there and actually reviewing the recording of the 17-year-old when they confronted the woman who came outside, that would have been at least enough information, enough evidence for the police to justify potentially detaining or maybe even arresting her for battery or assault. But here's the kicker. The woman they're investigating is now no longer standing outside. She's now within the protection of her home. Now, in this situation, cops are trained to perform what's called a knock and talk. And I want to remind you, a knock and talk is an investigative technique where the Supreme Court has said police officers have what's called an implied license, where they can walk up to your front door, knock on your door for investigative purposes. In reality, cops are hoping that you're naive enough to answer the door during a knock and talk so that they can ask you questions, and based upon either what you say or maybe what you even don't say, they can use it against you to possibly detain you, search you, or maybe even arrest you. But it's important to remember, Supreme Court law very clearly states that cops don't have any more authority at your front door than a Girl Scout or a delivery driver. Please understand, when cops try to use a knock and talk against you, courts have said this is a consensual encounter, which means if you don't consent, it's over. Unless a police officer has a valid warrant or true exigent circumstances, they cannot legally enter into your home. But wait, what about cops trying to use this flimsy excuse where they claim they can legally enter into your home without a warrant in the name of a welfare check or in the name of a community caretaking function? Let's see what happens, because that's exactly what they do here.
Stephanie, it's the police. Please come to the door.
Officers pounded on her door for about 30 minutes, making it clear to each other they were here to arrest her,
If she comes out, arrest her.
with no mention of obtaining a warrant.
Now, I want you to notice here, if cops wanted to legally arrest this woman in her home, there are some specific things that must be present. Number one, they either need to have a valid search warrant, or number two, this woman must be willing to answer her front door and step outside, which would there be consent. Or number three, there must be a true exigent circumstance. And when I mean an exigent circumstance, I mean there must be a true legitimate emergency where an officer could enter into that home. And I want you to understand, merely having probable cause of a possible crime going on outside does not provide the emergency necessary to invade the privacy of your home. Probable cause does not equal exigent circumstances. It must be a true emergency. So what does this mean? If I were standing there talking to these cops when all this was taking place, I would ask them, if you're knocking on this door and no one comes to the front door, what does that indicate to you? It indicates, number one, either the person inside the home doesn't want to talk to you, or number two, there may be no one in the home to answer the door. As a result, the cops must leave, especially when you learn that the cops were standing outside this woman's door, beating on that door for over 30 minutes. That should be crystal clear to these officers that this woman did not want to answer the front door, and by forcing their way into her home, it was a Fourth Amendment violation. Now, I've talked about this on videos in the past, but if cops show up at your front door performing a knock and talk and they just camp out and they refuse to leave, this is a Fourth Amendment violation. Why? Because when police are at your front porch, they are on what's known as the curtilage of your home. The curtilage of your home is the area immediately surrounding the inside of your home, right on the outside of your home, like your front porch, your back porch, maybe the areas right outside where your windows are. In fact, the Supreme Court has said that when cops are on the curtilage of your home, you have the same level of Fourth Amendment protection for your curtilage as you do the inside of your home from a search and seizure perspective. Now, as a reminder, the only authority that a cop has to go onto the curtilage of your home is under that implied license theory we talked about earlier on Knock and Talks. Now, the Supreme Court gave some specifics about this implied license here. They said that an implied license assumes, it means that you would be receptive to an uninvited guest at your front door. To be clear, when cops come to your front door and knock, they are uninvited guests. And even in this situation with this woman, where someone was claiming she did something illegal outside, they are still uninvited guests when they come knocking on her door. And if she doesn't answer the door, they must leave and go get a warrant to come back and knock again. Now, here's the other issue. These cops came to this woman's front door and boldly claimed, as they were banging on the door, they boldly claimed to all the other onlookers that they were about to arrest this woman. And from a constitutional perspective, that is a problem. Why? Because the implied license under a knock and talk does not include the license to arrest someone and just camp out or pound on the door until they answer. The real question here is, was this woman open and receptive to being arrested in her home? No one is. So number one, they couldn't do it under a knock and talk. Number two, cops did not have a valid warrant. Number three, there was no real exigent circumstance, no real emergency that would justify the cops breaking in this woman's door. And when we look at established emergencies under Supreme Court law, she was not actively destroying evidence, and she certainly was not a fleeing felon. In fact, in the recent case of Brazula versus the City of Sparks, both the Ninth Circuit and the U.S. Supreme Court ruled, and I quote, "Detaining and questioning a suspect on the curtilage of their property without a warrant constitutes a presumptively unreasonable search and seizure under the Fourth Amendment, unless an exception to the warrant requirement applies." The judges went on to say, the officers detained Brazula on the curtilage of his home without a warrant or probable cause, and questioned him while he repeatedly asked them to leave. In other words, unless cops have specific exigent circumstances, a true legitimate emergencies, cops cannot just come, bang on your door, hang out, refuse to leave your porch, or break down your front door in order to get what they want. Now, I want to ask you, how safe is your online information? In today's digital age, a hacker can access your home address, your contact information, and even your social security number in mere seconds. To be frank with you, I myself was hacked, and I felt so powerless in that situation, and I wish I had known about the ultimate solution, and that solution is Cloaked. Cloaked identifies and removes your personal information from data brokers and shady websites, then generates on-demand aliases to disguise your phone number, email address, and even your credit card. It's like having an invisibility cloak for your personal information. I don't wish how I felt when I was hacked on anyone. You can secure yourself by signing up for Cloaked when you visit cloaked.com/HamptonLaw and receive 20% off your subscription when you use the code HamptonLaw at checkout. That's CLOAKED.com. Get Cloaked and protect your privacy before it's too late, because your data deserves to stay yours. Now, just when you think things couldn't get any crazier, the cops continue to interview neighbors in the neighborhood, and they find out that this woman had taken some sleeping pills earlier in the day. So when they learn this information, what do? They use this information to justify breaking down this woman's door in order to perform a welfare check on her to make sure she didn't take too many pills. Watch this.
She called me about 20 minutes ago.
A neighbor then tells one officer that Rapkin took a sleeping pill 12 hours earlier.
I know she took a dose this morning, and then probably another couple of doses because she couldn't get to sleep. So she's taking multiple doses of sleeping medication? I don't know. She might.
Police decide they're going to break into the locked home to do a welfare check.
Wow. I know some people watch my videos and they think that you have nothing to worry about if you're doing nothing wrong. But in reality, unfortunately, that is just not true, particularly when you're dealing with police officers that are either inadequately trained and they have no idea what they're doing according to the law, or they're brazenly ignoring the law and doing whatever they want to in order to get what they want, which in this situation was to break down this woman's door. There is no legal basis for these officers to break down this woman's door. What they are doing here is not a mistake. It is inexcusable. Why? Well, think about this. Cops were told that this woman had taken some sleeping pills, and then cops started banging on this woman's door. They used the fact that she had taken pills earlier, and now she wouldn't answer the door, and they used this to cook up some imaginary emergency that justified them being able to break down this woman's door. Does that really justify this under the law? Absolutely not. Here's the reality. People all over this country are taking sleeping pills during the day and during the night, either to help them with sleeping or maybe they have an addiction. But that does not in any way equate to an emergency for the police to bang down and knock down someone's door. Now, what were the cops thinking here? They tried to pull out the old standard that's been around for years, known as the community caretaking function. The Supreme Court explained the community caretaking function as, and I quote, "Police are inherently community caretakers because a police officer, over and above his weighty responsibilities for enforcing the criminal law, must act as a master of all emergencies, who is expected to aid those in distress, combat actual hazards, prevent potential hazards from materializing, and provide an infinite variety of services to preserve and protect community safety." Based upon what I just read to you, cops have claimed they have a special role as community caretakers to take actions they can justify that others cannot. If so, does that mean if someone says that you've taken a sleeping pill and you're asleep and you don't answer the front door, does that give cops the justification to literally take down your door and figure out what's going on? If that were the case, any neighbor could make up anything about you, and cops could take what they say and use it as a justification to completely violate your home's privacy and enter without a warrant and even break down your door. So what can we apply here as a rule? In the past, the Supreme Court had ruled that the community caretaking function could apply to homes until Canigula versus Strong. In Canigula, a unanimous Supreme Court ruled that although police are allowed to use the community caretaking function to perform a warrantless search on a broken down car where someone is stranded, that same behavior is not permissible at all when it comes to your home. Unless cops have a clearly provable emergency situation, they have no right to enter into your home unless they have a warrant. In this situation, let me ask you, do you believe the officers had an objective reason to believe that there was an immediate emergency taking place inside of this woman's home? In my opinion, no way. They just wanted to arrest her, plain and simple. Police just cannot kick our door in just because our neighbor claimed we took a sleeping pill and we are still asleep. Unfortunately, these cops just kept going and they forced their way into this woman's house. Let's see how this played out.
And several officers enter with service weapons drawn. Body camera video shows Rapkin walk down the stairs.
Gentlemen, do you have a warrant?
We're here for a community caretaker, okay?
Community caretaker, I'm perfectly fine. I am sleeping.
Where she was arrested in her dining room.
Turn around for her. Put your hands behind your back. Thank you.
You're gonna arrest me in my own home?
Don't.
No.
Don't start.
Don't.
Got it. Yep, I got arrested.
For sleeping in my own home?
No, for assaulting an individual outside.
Then a scuffle ensues.
Cancer survivor.
What is your problem? Relax.
Cancer
Relax.
survivor.
Okay, well, you don't knee me in my groin. You understand me? What is wrong with you?
Holly, did she strike you?
Yep, she did. Battery to an officer.
Rapkin was escorted out of her home.
Oh, great, you broke open my door.
No, but you weren't answering us.
To an applause from protesters outside as she's put in the patrol vehicle.
Now here is where things go very badly for the cops. Some of you may remember from one of my previous videos where I covered the case, the very important case, of French versus Merrill. This case was very important because the court ruled here, the Supreme Court ruled, that if police officers violate your Fourth Amendment rights while on your curtilage, let's say they come up and perform a knock and talk and it was illegal, or maybe they enter into your home without exigent circumstances, now they no longer have qualified immunity, which means you can bring a civil rights lawsuit against them. Now, the cops chose poorly in this situation because the woman they arrested was a lawyer. Let's see how this played out.
After the arrest, Rapkin, an attorney herself, hired lawyers to file a federal civil rights lawsuit. Her attorney, James Odell, says the case is all about a violation of the Fourth Amendment, which protects people from unreasonable searches and seizures by the government.
This cost Wisconsin taxpayers $760,000 because that's how much they had to settle for in order to avoid a trial. The most disturbing part of all of this is that not a single officer ever thought twice about kicking in this woman's door and violating her privacy rights. So how do we stop cops from searching our home in the name of a welfare check? Number one, remember, cops have a valid implied license to perform a knock and talk at your front door. But it's a consensual encounter, so you also have a right to ignore them and they must leave. As I've said before, don't answer the door. If you do, cops will use anything you say or maybe even what you don't say against you, and you could end up being detained, searched, or arrested. Number two, if cops come to your door demanding you must answer the door in the name of a community caretaking function or a welfare check, remember, under the Supreme Court case of Caligula, community caretaking does not apply to your home. The only way cops can justify this is they must have a true emergency, known as exigent circumstances, to justify entering your home. Number three, if you're going to still confront the officers when they come to your front door, don't let them in. Also, if they claim the community caretaking function, don't open the door or talk to them by walking outside. Instead, tell them you're just fine, you have no desire to speak to them, and you can end the encounter. This is a consensual encounter. And finally, if the cops still ignore your rights and violate your rights by kicking in your door anyway, make sure you always pull out your phone and record everything from start to finish. You want to make sure that everything that takes place here is actually on video so that you can hold the police accountable, just like this woman did in the video we saw just a moment ago, which allowed her to bring her civil rights claim against the county. And finally, if cops break down your door anyway, remember you can hire a civil rights attorney that may be able to take your case on a contingency fee, which will allow you to bring an actual cause of action against the police because now they don't have qualified immunity. You can actually potentially receive justice by receiving some type of payment in settlement or maybe take your case to trial. Now, we've covered exactly how to stop cops from using a welfare check to search your home. But what if cops come to your door and now as they start to confront you wanting to come in, they then start covering your cameras? Maybe they cover your Ring camera or your porch camera. Check out this next video where I break down how to stop cops if they try to cover your porch camera. See you over there.